All right, we're going to talk about whether or not Donald Trump is going to get his money back. He's going to get his deal back from FANI Willis. But before we do that, let's do a real quick jump back in time and remember exactly how we got here. Let's check it out.
Absolutely seismically huge news today that the case against Donald Trump in Georgia is being dismissed. This is likely the worst day of the year for FANI Willis.
Here tonight at 11, Georgia could be forced to write a nearly $3 million check to President Trump. I'm Blair Miller.
And I'm Carly Barnett. Today, Governor Brian Kemp signed a bill into law that allows defendants to recover fees and costs if the prosecutor of their case is disqualified and the case is dismissed.
Absolutely seismically huge news today that the case against Donald Trump in Georgia is being dismissed. This is likely the worst day of the year for FANI Willis. We found out today via a filing in the Fulton County Superior Court that Pete Skandalakis, who is the director of PAC, the Prosecuting Attorneys Council of Georgia, has filed a motion for nolle prosequi, which is basically a motion to dismiss the case. We had been waiting to see what he was going to do. If you've watched my prior videos, you know that he could not find anybody, any other prosecutor in Georgia that was willing to take on the case after FANI Willis was disqualified. So he had appointed himself temporarily because he wanted more time to look through what I'm sure was a lot of stuff, 101 banker boxes and an 8 terabyte disk drive, to make a determination of whether he was going to proceed prosecuting it himself or whether he was going to dismiss it. We now know that his decision is that he believes it is appropriate to dismiss it, and there's no reason to believe that the judge won't sign off on a dismissal in this case. But the big thing that I would suggest to anybody who has an emotional reaction to this, thinking that somehow Pete Skandalakis is some type of Trump lackey, needs to read the 23 pages before you make that knee-jerk reaction, because it is a very well thought out set of facts, in my view, and it is not one that says that there is nothing wrong with what happened in 2020 and 2021, but rather it is not something that is appropriate to be prosecuted, especially here in Georgia, with one minor exception. So I'm not going to read through all 23 pages with you, but I'm going to hit the highlights for you so that you can kind of understand what his thought process was. So let's start by this. Let me tell you, he divided his reasoning into basically 5 major areas. He looked at the Republican electors and what they've been accused of. He looked at the allegations of violating the election equipment in Coffee County. He looked at unsworn statements given to the Georgia Assembly, and he talked about the efforts to influence the Fulton County election workers. And then the last thing he did was talk generally about the case against Donald Trump and his co-defendants. And what he's doing, remember, is assessing whether or not it is viable and wise to go forward with this prosecution. So let me hit the highlights for you. So one of the first things I noticed about this written discussion on why he decided to dismiss the case was him emphasizing how seriously he is taking his role, and I really do appreciate that. He notes that, of course, he was unable to find a conflict prosecutor that was willing to take on the case. And then he cites something, a quote from something back in 1940, where he notes that, quote, "The prosecutor has more control over life, liberty, and reputation than any other person in America." And I do think that that is a really important thing for him to acknowledge, because we've talked for so long about how much a prosecutor can negatively affect someone's life if they don't do their job properly. We've seen it with Mick Patel in Cobb County. So I do appreciate that he notes that. He then goes on to talk a little bit about the process and some of the things that he looked at in evaluating the case overall. And he says that he began the process by evaluating this case with a basic truth. It is not illegal to question or challenge election results. And he notes that this has actually happened on both the red side and the blue side of things. In 2018, Stacey Abrams questioned the legitimacy of Brian Kemp's victory in the gubernatorial race. Likewise, in 2020, many Republicans struggled to accept the reality that President Donald J. Trump did not win the popular vote in Georgia or in other key states, and therefore lost the presidential race. Down further, he says, unfortunately, as this case demonstrates, there are attorneys who overestimate their expertise and provide flawed or unlawful advice to the public, and most concerning, to unsuspecting non-lawyers who rely on it. So he is putting a lot of the onus on this on some lawyers that didn't do a very good job. But again, this is a very reasoned and balanced approach that I can see. So he then goes on to look at the indictment itself. And he says that he has to highlight for everyone that while a RICO case can involve activities that happened outside of the state of Georgia, at least one or more criminal acts has to have occurred in Georgia in order for jurisdiction in Fulton County to be appropriate. And so in order to move forward his analysis, he says, I have elected to focus solely on the acts that can be proven within the state of Georgia. So he's looking at what those core acts were here in Georgia that would even allow the prosecution to go forward in Fulton County to begin with. So now he moves from there to the different categories that I told you about, where he's assessing each of the different areas of the RICO case. So he starts with the Republican electors. And he notes that these Republican electors lacked criminal intent, the very basis that you need to prosecute pretty much any case, any criminal case in Georgia, that they simply didn't have criminal intent in the way that they acted. That when they got together and cast their votes, they had cast their votes based on the advice of attorney Ray Stallings Smith III, who they reasonably believed to be knowledgeable in election law. So he's saying that even if the actions that they took were distasteful, they were done so in a manner that they believed they were actually doing what they were supposed to be doing, and they had relied on a lawyer in doing so. He goes on to say at the very end of this analysis of the Republican electors that several of the alleged overt acts, the things that you need to put together a RICO count, concerned public statements made by Republican electors. And I really like that this sentence that I'm about to read. He says, "I have grave concerns that prosecuting individuals for such speech would raise serious constitutional issues. In light of these concerns and recognizing the limits of the state's prosecutorial authority, I decline to pursue these charges." So he is saying, with regard to the Republican electors, a lot of what they had to do relied on attorneys and their advice that these electors were relying on, who they thought would be knowledgeable people. And also with regard to our constitutionally protected speech, he's simply not going to go after them. He doesn't think that it's appropriate. So I really like that, because from the get-go, and we'll touch on it a little bit later, a lot of people, the problem that they had with this criminalization of these actions was a lot of people saying this was their right to have opinions, and it shouldn't be criminalized. Whether you like Trump or not, it shouldn't be criminalized. So then he moves on from there to analyze the unsworn statements of the General Assembly. This is another element of things that were in the RICO counts that were indicted against Trump and his co-defendants. And he talks about Rudy Giuliani, Ray Stallings Smith, who I just mentioned, and Robert David Cheeley, that they had been indicted for criminal contact for allegedly giving false statements to committees of the Georgia Assembly. But in the next sentence, he says, these statements were unsworn. So this wasn't a situation of perjury. They hadn't violated the law by giving false testimony during sworn statements. He says, and this is huge, he says he finds that defendants Giuliani, Smith, and Cheeley's statements were wrong and baseless. So he's not saying that they weren't without wrongdoing. It just wasn't necessarily criminal wrongdoing. He goes on to say, criminalizing such unsworn testimony would have a chilling effect on witnesses appearing before the legislature on important issues. So if people go forward and are willing to voluntarily speak to the legislature, even in an unsworn capacity, to worry about the fact that they could be criminally charged if people decide to go down that route, is going to make people say, look, I'm not going to testify. So I appreciate that. Again, it's key. It was unsworn testimony. It was not perjury. Now he moves on to the breach of the Coffee County election equipment. And he notes that the primary architects in this were Sidney Powell and Scott Hall, two of the people that were included in this indictment. But he also notes, hey, look, they've already pled out. They have pled to misdemeanors. And he says that any further prosecution with regard to that doesn't feel to be necessary. David Schaefer is another person that was accused of making 2 false statements while interviewing with Special Prosecutor Nathan Wade. But he goes on to say, look, he voluntarily came in to talk to Nathan Wade. He made himself available for an interview. He says that it was a lengthy interview with open-ended questions. Mr. Schaefer was doing his very best to recall events. And the fact that he made some responses during that he recollected incorrectly, that doesn't rise to the level of being false or misleading. He also looks at another statement made by Mr. Schaefer and says that it doesn't withstand any kind of scrutiny with regard to him recalling whether or not there was a transcript available. So when you look back on that, it's completely insane. This person comes in to voluntarily talk to Nathan Wade, does his best to remember. Apparently it was like a year after all this had happened. He's trying to remember events. He doesn't remember them exactly correct. And I guess that they decided that must be criminal behavior. If you didn't recall something correctly when talking to a prosecutor voluntarily, they're going to charge that. Scandalakis doesn't mention this, but again, a chilling effect on people being willing to come in and talk to a prosecutor. And he notes, like I said, that their answers were not, his answers were not false or misleading. Okay, so now he moves on to looking at the allegations against some federal officials. He talks about Jeffrey Bossert Clark, and he says that the RICO count, this is not a nice sentence when it comes to Fani Willis's indictment. The RICO count and many of the predicate acts, meaning the underlying acts that have to happen in order for a RICO count to occur, continues to unravel when one scrutinizes the allegations against federal officials Clark and Meadows. So from the get-go, he's already saying this RICO indictment was not done well. He says the charges brought against Clark were especially concerning. They plainly fall short of the far more rigorous standard of proof beyond a reasonable doubt required to sustain a criminal conviction. So again, from the get-go, he's saying, look, might not like what they did, but it hardly rises to the level of something that a prosecutor could prove to a jury beyond a reasonable doubt. Specifically, and me as an attorney, this kind of raises the hair on the back of my neck a little bit. They went after Clark because of apparently a letter that was never signed, that was prepared. It was labeled pre-decisional and deliberative attorney-client or legal work product. So I do not have an encyclopedic knowledge of these RICO counts in detail, but apparently there was a letter that was prepared that was provided to some folks, one of whom was the Deputy Attorney General, and the other, that it was going to be sent over potentially to the governor of Georgia. And it was a draft letter that they had talked about, but upon discussing it more, the Deputy Attorney General said, I'm not signing that. I won't sign anything remotely like this. So it was never sent out. And they used that letter as a basis for this RICO Act. And he says the letter was never even approved. So again, this is the language that I really, really like. He says, giving advice that is rejected is not a criminal act. It is simply an attorney fully explaining a matter to a client. Routine internal debate between attorneys should not be transformed into criminal conduct, and doing so sets a dangerous precedent. So shout out to a prosecutor for acknowledging that defense attorneys often have to do this same thing. Discussing how we may go about defending a case is not something that you should later criminalize. So that had caused a lot of heartburn for a lot of lawyers, that kind of thing had been described as criminal conduct by FANI Willis and Nathan Wade, when indeed it was attorney work product that was never signed and never floated. He then goes in to talk about Mark Meadows, and I know a lot of people don't like Mark Meadows. He's former chief of staff of Donald Trump, but he describes some of the activities that Mark Meadows did when he was chief of staff, coming down into Georgia, getting involved in the election, counting, all of those things. And he does acknowledge he might have gone a little bit outside of his job, saying the blurred lines between campaign duties and official duties do not provide an easy and obvious answer. His actions, both in Georgia and other states, remain subject to interpretation, which is a nice way of saying he was out of line. But everybody remembers the famous phone call to Brad Raffensperger, the Secretary of State of Georgia. This is what he says about that. Regarding the phone call to Georgia Secretary of State Brad Raffensperger, at no point did Meadows or President Donald Trump explicitly solicit the Secretary of State to violate his oath of office. While the call is concerning, he goes on to say, reasonable minds could differ on how to interpret the call. So I know the people that hate Trump are going to go off the rails right now and say, that's it, it's unacceptable, he's in Trump's pocket. He does say in Georgia, a person will not be presumed to act with criminal intention. A jury or judge may find that they have such criminal intent upon consideration of the words, conduct, demeanor, and motive. So he was looking at this purely from the point of view of a prosecutor who is saying, here are the facts of what happened. How could a jury interpret these? Can I get to beyond a reasonable doubt? This is what he says. While I am convinced there is currently insufficient evidence to bring Meadows to trial, I am deeply troubled that neither the state, Meadows, nor his defense attorneys have been able to access Meadows' diary and notes from the National Archives, which may be critical to his defense and potentially exculpatory. So while everybody's been talking about the call, he says there are diary notes, those kinds of things that exist that are being held by the National Archives, and the defense nor the prosecution can get access to them. Apparently, Judge McAfee had said to the federal government, hey, we need this material. And the federal courts said, no, we're not giving it to you. They said you lack subject matter jurisdiction, meaning, nope, it's just a state case. We're not giving it over. And so again, shout out to Mr. Skandalakis for saying, it is therefore contrary to the interests of justice to pursue a prosecution in which a defendant may have a legitimate defense, but is unable to obtain key documents solely because the case is being tried in a state rather than in federal court. So if you are going to go off the rails and say, but this phone call, find me the votes, you have to have support of the criminal justice system, which also says a defendant is entitled to exculpatory documents, and they are being not made available by the federal government itself. So if you're one of those folks that hates Trump, then you got to at least say a defendant has a right to certain things in a trial, and you should support that as well. And so his conclusion there is pursuing charges against Clark and Meadows under these circumstances, it's not justified. They have not been allowed to get the evidence that they are entitled to. Now, here's where he takes a little bit of a turn, and I want everyone to pay attention to this one. He talks about the victimization of Miss Ruby Friedman. He says she is a genuinely sympathetic figure. She was subject to harassment and threats due to some statements made by Rudy Giuliani and others with regard to alleging some voter fraud on her part. And he says the evidence in this case shows the allegations occurred solely in Cobb County, where Ms. Freeman resided. He goes on to note that the charges themselves, it was very far removed, that those actions alone would not have tipped the election in any way, shape, or form. So he says they're too tenuous to be part of a RICO count. But he says if they were to prosecute those alleged crimes, they would have to be prosecuted in Cobb County. Remember, FANI Willis filed them in Fulton County. Now, let's take a pause, because this is very interesting. It is the only thing in this whole 23 pages of the dismissal. It's 22 pages of exhibit and plus the motion to dismiss. It's the only time he says there might be one little thread still hanging out there. All right. And this is where I always have a question. So the statute of limitations on a RICO case in Georgia is 5 years. But you have to remember, too, that there was a long pause during the COVID that pushed way into from 2020 into 2021. And Cobb County actually had an additional little pause beyond that for reasons because our clerk couldn't find her way out of a paper bag with a map and a flashlight. So we had all sorts of problems there, too. So it's possible, I haven't done the math, that there could still be a RICO case to be filed against the folks that went after this Ruby Freeman person. Is Sonia Allen in Cobb County going to do Fani and Nathan, her buddies, a favor and pick this one up? If the statute of limitations is still viable, that's going to be interesting to see, because she is buddies with them and would do them a personal favor for sure. Well, of course, she didn't pick it up before, so maybe she's not such a good friend. All right, so now we get to the big kahuna, the Donald Trump and his campaign advisors. What did Pete Scandalakis say about that? Well, first thing he talks about is the obvious thing. He's the sitting president. Nothing's going to happen while he's the sitting president. So he says, even if by some extraordinary circumstance, President Donald Trump were to appear in Georgia on January 21, 2029, the day after his term concludes, an immediate jury trial would be impossible. Of course it would. There's going to be litigation of immunity issues, all sorts of things like that. He notes all of that and then says, bringing this case before a jury in 2029, 2030, or even 2031 would be nothing short of a remarkable feat. So we know that it is going to drag on, and that, even motions issues may get appealed up to the appellate court, like we've seen with Fani Willis getting disqualified. So getting this in front of an actual jury is going to take forever. He also notes that so much of this really belongs in federal court, not in state court. He talks about special counsel Jack Smith, and he says, Jack Smith had similar analysis. This is also why special counsel Jack Smith's federal investigation and prosecution would have been the most appropriate avenue to determine whether the actions of those involved were crimes that could be proven beyond a reasonable doubt. Scandalakis says he even considered severing some of the defendants, and severing just means splitting them off and trying them separately. But he said that would be illogical, unduly burdensome, and costly for the state and for Fulton County. So separating people out, maybe doing them before you got to President Trump, still going to be complete chaos. This is where people might get angry. It says, I am extremely reluctant to criminalize the acts of attorneys providing flawed legal advice to the President of the United States under these circumstances. Now, I like this statement, but again, people are going to say those lawyers were his lackeys. He shouldn't have a free go of it. But certainly these lawyers should be held accountable to their respective state bars for any violations of professional conduct, and some have faced such accountability. We know that Rudy Giuliani got disbarred. But prosecuting these attorneys and advisors without President Trump would be futile and unproductive. So he's not going to split them off. Finally, he says the big issue that many of them would have would be constitutional speedy trial rights. To uphold the constitutional speedy trial rights of the remaining defendants, PAC would have to commence trials immediately, which would be a huge burden on all of them. And so he decided, in my professional judgment, the citizens of Georgia are not served by pursuing this case in full for another 5 to 10 years. Okay, so as you can see, he's gone through and analyzed each different section, and he has a really good closing on this too. And let me just caveat here, I don't know Pete Scandalakis, never met the man in my life, never had a conversation with him, period. He says, the strongest, and if you hate Trump, listen up, the strongest and most prosecutable case against those seeking to overturn the 2020 presidential election results and prevent the certification of those votes was the one investigated and indicted by Special Counsel Jack Smith. Although Special Counsel Jack Smith's federal case encompassed evidence from multiple states, he ultimately concluded the federal case could not be prosecuted because of the U.S. Supreme Court's decision in Trump v. United States and the re-election of the president. So what he's saying is, again, not that everybody here has clean hands, but that this is something that which is left over that was prosecutable should have been handled in the federal prosecution that was investigated by Jack Smith. The criminal conduct alleged in the Atlanta Judicial Circuit was conceived in Washington, not the state of Georgia. The federal government is the appropriate venue for this prosecution, not the state of Georgia. He goes on to say, after reviewing this case and considering the Supreme Court's decision in Trump v. United States, along with all the years of litigation that such a case would inevitably entail, he has concluded, this is now what we're talking about, Scandalakis, that such prosecution would be fruitless, and he finds that too. And like Jack Smith determined, it wouldn't have been productive in the federal government as well. So finally, excuse me, his last line is, my assessment of this case has been guided solely by the evidence, the law, and the principles of justice. All right, so that's my lengthy but not 22-page long analysis and highlights of what's important in this case. And I want to say one more thing. If you are a person that has decided that they think it's appropriate to threaten Pete Scandalakis and his family, then I don't even have words for you, because this is a man who was assigned this responsibility, took it very seriously, has no doubt been spending 24/7 reviewing all of these documents to make a determination as to what is the best course of action. If you are one of those people that decides to put out a death threat, you're an idiot, and you're likely going to be prosecuted for that as well, because terroristic threats, people, that is indeed a felony in Georgia. So I'll close with this. I know I've been really long-winded. I apologize. I really wanted people to understand how this got dismissed. It wasn't just I'm a Republican, I don't want this to go on. It was a very reasoned and thought-out decision that did not say that there was no wrongdoing, okay? It's just analyzed whether it's appropriate in Georgia, whether some of these things could be proved beyond a reasonable doubt, and whether or not the timeline that would go into prosecuting this case is worthwhile in the end. So I think it was a neutral analysis. That is my opinion. I am sure you will have your own. It is going to be interesting to see whether Sonia Allen, if able to, picks up that little thread in Cobb County. I guess I'll let you know if I hear anything more about that. I hope everyone has a lovely holiday.
It's been an expensive ordeal. Let's go talk about what happened with Trump and his one-time co-defendants. Now, they are in dismissed RICO case, will likely sue for millions under new Georgia law about prosecutor disqualification. There's a small part of this article that I really want us to hone in on. I'm going to read through it. I'm going to talk about the small part as well. Let's go. Now that the criminal racketeer RICO case out of Georgia against President Donald Trump and several others has been fully put to rest, the civil cases are soon likely to bloom like peaches on a tree. That's very well written. Shout out to Georgia. Shout out to law and crime. Shout out to law and crime. Let's go. Earlier this week, the long beleaguered RICO case brought by Fulton County District Attorney FANI Willis was finally dismissed by the Fulton County Superior Court Judge Scott McAfee. Scott should have dismissed it a long time ago, but I digress. In dismissing the matter, the court signed off on a motion by the acting prosecutor who described the case delayed for 2 months, shy of 2 years, as on life support and a waste of time and money. And now recent litigation suggests that Peach State's money is likely to flow to the opposite direction. That's wild. In March, the Georgia legislature took Senate Bill 244, which provides reasonable costs and attorney's fees to a defendant in a criminal case if the prosecuting attorney is disqualified due to improper conduct. I just want us to remember this term, improper conduct. Just ask yourself, was FANI Willis disqualified because she did something improper, or was it because of the appearance of doing something improper? Just give you something to think about. Noodle that while we continue. In April, the State House passed the bill in May. The Senate passed the bill, which was then signed by Governor Brian Kemp. The language of the final bill offers a suite of recoupment opportunities based on the end results of a successful disqualification. The law went into effect the first day of July. The law reads in a relevant part: if the disqualification of the prosecuting attorney results in the criminal case being dismissed because the defendant who filed the motion for disqualification due to improper conduct, the defendant who filed the motion for disqualification shall be entitled to an award of all reasonable attorney's fees and costs incurred by the defendant in defending the case. The defendant who filed the successful motion for disqualification of the prosecuting attorney based upon the misconduct of such prosecuting attorney. This is the only thing I want you to think about. Not only thing, but based on the misconduct of the prosecuting attorney shall file a motion for reasonable attorney's fees and costs upon termination of the underlying criminal case. The judge to whom the criminal case was assigned shall consider such motion for a reasonable attorney's fees and costs and shall reward such reasonable attorney's fees and costs as provided under the code section of such defendant. Other avenues of redress are available, for example, to a defendant who only disqualifies the prosecutor but fails to dismiss the case, and when such fees and costs are awarded, the money shall be paid from the treasury of the county in which such criminal case was brought. While exact numbers are unavailable, the defense of the case, which began in August 2023, so literally, I think it should be considered 2 years, but I know there's those long breaks in between that they're excluding those out of there, almost certainly amounted to millions of dollars in legal fees incurred by the multiple people charged. The 45th and 47th president costs alone likely ran into the millions, and he will certainly avail himself of the rights under the new law. Now that the President Trump has won his Georgia case, we will be moving for attorney's fees and costs under Georgia Code. Steve Sadow, Trump's lead attorney in the case, recently told Atlanta-based ABC affiliate. Other co-defendants say they will take advantage of the opportunity as well. This has been a long ordeal, Chris, attorney for Robert Cheeley, told the TV station. It's been an expensive ordeal and he's very relieved and grateful about the non-prosecution that came about today. All right, I want you to think about it because I'm not 100% certain. I don't know if Fani Willis was dismissed because she did something wrong or there was the appearance of something wrong. So let's look at the bill, and here it is right here. I'll leave the link down in the description as well. I'm going to start right here, line 18. You all know I'm not a legal expert by any means or measures, but here's the thing that I'm just worried about. If the disqualification of the prosecuting attorney, that would have been Fani Willis, results in a criminal case being dismissed, okay, we got that, against the defendant who filed the motion for disqualification due to improper conduct, this is the only problem I have, because the language has always been that there's been the appearance of impropriety, the appearance, but not the actual improper conduct. I'm concerned about that part. The defendant who filed the motion for disqualification shall be entitled to an award of all reasonable attorney's fees and costs incurred by the defendant in defending the case. If the disqualification of the prosecuting attorney shall result only in the qualification of prosecuting attorney in the underlying criminal case proceeds to trial, which we know that doesn't apply because the whole thing is getting tossed out on its ear. I just wonder, and I'm sure we'll keep our ears, I'm sure we'll hear more about this, but due to improper conduct, I don't know if Fani Willis actually, they found that she did something improper more than there's an appearance of that she did something improper. It sounds like you're just really trying to parse words, but I really think that might come back. So I want to hear what y'all think about it. Give me your 2 cents. I'll leave this article the news article as well as this bill down in the description. So check it out. Give me a 2 cent and I'll see you all there. Grace and peace. Thank you so much for tuning in to another episode of the JWhit Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.